Hello and welcome to another edition of East of Ethnia. It is time to talk about genocide again, I'm afraid. And why is this? It's because some events going on in some ongoing violent conflicts in the world, I think, are leading to a situation where courts are going to be compelled to adopt a broader definition of genocide than what they have been using so far. You will recall that early on, particularly during the violence in Gaza, um, I made the criticism, other people made the criticism, that a lot of the things that were being charged, that were being argued as constituting genocide, didn't in fact constitute genocide. These were war crimes, and the distinctiveness of genocide needed to be preserved. It's time to revisit that argument. And why is that? Well, let's begin by asking a question. Why is it that we recognize a distinction between genocide and war crimes at all? What is the importance of this distinction? There are a couple of reasons for this, but I think what's worth pointing out here is that all of the reasons are political. If you look at the debates in the United Nations that accompanied the adoption of the Convention on Genocide, you'll find that among the main advocates for a relatively restrictive definition of genocide were the United States and the Soviet Union. They were especially interested in maintaining that the effect of the violence had to be large enough to make it distinctive. That is, they did not want ordinary war violence and massacres to be counted as genocide. And they also both insisted on this restrictive definition of groups that we have in the Genocide Convention, that it be national, ethnic, racial, or religious groups, and not, for example, groups defined by politics. This was done for the purpose of reserving the ability to make political arguments to a court in the future regarding genocides that both states had committed in the past and were likely to commit in the future. Another political reason probably has to do with the rise after the end of World War II that became pronounced in the 1980s and 1990s of civilian victims as political subjects, rather than the way that they were considered before, which is largely as byproducts of war, in which the actors were states and their military forces. But the main political reason for maintaining a kind of uniqueness, distinctiveness of genocide was the recognition that um, if an act was recognized as genocide in the world, this constituted political capital for the victims group, allowing them to claim recognition, concession, and other things. This has been effective, and it's meant that there has been a sustained political interest among groups that are recognized as victims of genocide to try to maintain the uniqueness of this distinction. And so far, courts have maintained this narrow and restrictive definition of genocide that you could argue was established with the adoption of the Genocide Convention in 1948. And they have done this, I mean, in some ways through the invention of doctrines. I mean, one doctrine that did not become a precedent was the doctrine developed at the International Criminal Tribunal for the former Yugoslavia on specific intent, trying to argue that the stated purpose of providing military assistance to a group had to be in order to allow crimes to be committed, in order for somebody to be guilty of complicity or of aiding and abetting genocide. As it turned out, every time this doctrine was tested before other courts, it was rejected, and eventually it was rejected by the tribunal itself. But the purpose there was to preserve the privilege of states and militaries to develop policy, including policies that involved aggressive violence. Now, what a lot of this turns upon is, and I'm going to show you a picture now. It turns upon some specific elements of Article 2 of the Genocide Convention. And I'm going to show you Article 2 of the Genocide Convention right here. So take a look at the first paragraph of Article 2, and there are these two words that we always focus on. One of them is intent, and the other one is group. So a lot of the argument that courts have made to justify the narrowness of the definition of the Genocide Convention has had to do with what constitutes evidence that is acceptable to courts of intent. And they tend to want direct evidence. That is, they tend not to accept a pattern of acts as constituting evidence. And what constitutes a group? How big does a group have to be in order to be a group? The standard that is developed is that the effect of the killing has to have been meaningful enough that it alters the life or the ability of the group to sustain itself. Now, remember, this narrow definition has been meaningful. One of the things that it has meant is that courts have really only recognized 2 genocides in the whole period since the Genocide Convention has been passed, and that is the genocide in Rwanda and part of the genocide that took place in Bosnia and Herzegovina is the genocide at Srebrenica. Implicitly, they recognize a 3rd genocide, the World War II genocide against Jewish people in Europe, but not against other groups in Europe that were also targeted in that genocide. Well, what's happening now because of things that are happening in the wars in Ukraine and in Gaza? It looks like there is pressure on courts to change definitions. Now, I'm going to show you Article 2 of the Genocide Convention again. So let's get back to that screen share and put up article in Ukraine. You're beginning to see you saw this more at the beginning of the conflict in Ukraine when that was in the news, but this is still happening. Take a look at Section E of Article 2, that is forcibly transferring children of a group to another group. This was happening on a large scale, especially toward the beginning of the conflict in Ukraine. Children were kidnapped from Ukraine, brought to Russia to be adopted and by other families, educated as Russians, but it's also the political importance of this conflict that's led to pressure for the violence to be recognized as genocide. So some institutions, the European Parliament has done this, for example, are looking back into history, taking a look at the artificial famine that was created in the 1930s in Ukraine, the so-called Holodomor, death by hunger, and are now saying that was a genocide. This famine in Ukraine in the 1930s used to be taken as a textbook example of a large-scale instance of killing that was not a genocide because the victims were identified as political opponents rather than a national group. So that revaluation is being forced. If you take a look at the conflict in Gaza, I mean, one of the things that happened when South Africa brought its case against Israel for genocide to the International Court of Justice, they did this early in the conflict, and they kind of overstated their case. They described things that constituted war crimes as being genocide. They said that Israel was doing things that there were indications that it might do in the future, but hadn't done yet. Israeli politicians and the military sort of, you could say that South African lawyers went off the deep end, and the Israeli politicians and military leaders jumped off the boat to meet them at the deep end. And they started taking these arguments that were offered by the legal team of South Africa and using them as a guideline for action, as a kind of roadmap of what to do. And in doing that, one of the things that they have done, we're going to do the screen share again. Here is the screen share, going back to Article 2 and take a look at Article 2, Section C, creating, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. This is the main basis on which there is a plausible argument against the Israeli military and political leadership for committing genocide. I mean, not only with the scale in which it is targeting civilians in places like Rafah, but also by the deliberate blocking of arrival of humanitarian assistance to civilian victims, including food and so on. So they have opened themselves up to the charge of genocide in a way that they were not open before. So this is the argument that I want to make, is that the scale of violence in Ukraine and the resolution of Israel to ignore the findings of the International Court of Justice are going to have the effect of forcing courts to broaden the interpretation of the Genocide Convention that's been in operation so far. So we've said the precedent for genocide so far is a very narrow and restrictive definition, but a precedent is only a precedent as long as it continues to be followed. This is very likely to change. Now, having said this, I still want to say a lot of these legal arguments about genocide are arguments for lawyers. They are not necessarily of interest to other people interested in the general fate of humanity, remember always that the debate about large-scale violence is not at the bottom a debate about definitions. It is a debate about the obligation that is globally shared to protect civilians from violence. The rest of it you could just call inside games in a certain profession. Thank you for your time and attention, and we'll talk to you again next week or so.